I welcome you all on behalf of Nani Palkiwala National Law Club. Today we have a topic about the company laws. As we know, the Company Act has the highest number of the provisions, that is 400 plus, which deals on the different matters related to incorporation of the companies, then what are the different compliances that we have to do, then how the white collar crime should be dealt when fraud is happening within the company. Then we have a shareholders whose compliances are done and how they are dealing with the companies with the management when the management and ownership are different with the shareholders. So today we have a different case laws which will be discussed by our guest advocate Jayprakash Somani, who is the advocate at Supreme Court of India and dealing different cases on related to company law. Over to you, sir.
Thank you, Manoj. Thank you very much. Friends, this Companies Act is very exhaustive and most significant in corporate law series. If you want to go through all corporate laws, you have to visit our website jayprakashsomani.com and visit on blog page. You will find our blogs. On my LinkedIn account also blogs are there. So in that block number 1 to something I think 5 to 7 blogs are related to the index of the corporate laws. Near about 42 corporate laws are there in our country. And then gradually from next onwards, we have discussed Company Act in that. So Company Act 2013 have 470 sections, 29 chapters and 7 schedules. But this is not sufficient for law practitioner as well as for chartered accountant to deal with company affairs, to corporate affairs. Because law provides only legal provisions. Law doesn't provide its procedural part. So procedural part of the Companies Act are classified into rules. Total 37 rules are there. If you want to see all rules, list of all rules, then on our website blog page, I think block number 9, in block number 9 of corporate law block series, you will find all 37 rules. So always remember that whenever any case related to company law, suppose related to the accounting, related to the director discipline, so for every rules are there and we have to go to rules. And when we are the lawyer of defendant, our action process will be different. When we are lawyer of the petitioner, our action process is different. So whether we are representing case from the client of corporate sector or whether we are in the case through the government, so our action will be different. Our interpretation process will be different. So for that purpose, always remember Company Act, you refer Company Act, that particular section, then goes to that particular rules, see the rules and see if you are a dependent lawyer, then see how the officers of the government officers misuse the procedure. You are not followed the procedure properly. And if you show that, then result will be in your favor. We are not discussing all these things today. We are discussing near about 10 to 15 judgments. In short, 10 to 15 significant judgments we will see. But what is the purpose of this today's judgment? So today's judgment reflects the evolving nature of corporate law in India through the lens of the Companies Act 2013. They encompassed issues ranging from corporate governance, responsibility of directors, to regulatory compliance emphasizing the need of transparency and accountability within a companies. Supreme Court rulings plays a vital role in interpreting the law, setting precedents, and ensuring that the spirit of Companies Act is upheld for the benefit of all stakeholders involved. So, friends, ready to hear the step by step all these 10 to 15 cases. Case number 1, Lalita Tiwari versus State of Uttarakhand. This is 2017 case. This case involved a dispute regarding the wrongful termination of a company secretary. Wrongful termination of company secretary and associated duties under the Companies Act. And Supreme Court held in this case, Supreme Court held that the provisions of Companies Act concerning the protection of the company employees should be strictly interpreted. So, ratio decidendi comes out of the case. Employees' protection under the Act cannot be overlooked, regardless of the personal disagreement in management. Even though there are some personal disagreement in management, but as per company laws and rules that particular, so there should be a proper protection to employees under Companies Act. And section involved in this case was section 203 and 204 of Companies Act, which is related to the appointment and remuneration of managerial persons. Citation, Criminal Appeal number 538 of 2017. So this is related to the employees protection. Now, second case, Amity University versus New Okhla Industrial Development Authority. This case was decided in 2018. This involves a dispute about the classification of company under the article of the Act. Supreme Court classified that private universities act as a companies but are not for profit. So, non-profit company. This was the decision of the Supreme Court. Ratio decidendi from this case, ratio decidendi means the main education which Supreme Court wants to give to the general public of India, that is ratio decidendi. This distinction affects taxation and regulatory compliance. So, section involved in this case mainly section 8, non-profit organization. Earlier in the 1956 law, this case section was a section 25 company, but now non-profit company is registered under section 8 of Companies Act 2013. So you can call as a trust also, but Trust Act is a different. So NGO you can register in two ways, through Trust Act also and through Companies Act also. Company have the corporate status, so all over national, international level, that is always better to register your trust non-profit organization when you are running schools, when you are running colleges, when you are running charitable hospitals or regular hospitals, which is not meant for the earning profit. Obviously, without money you cannot survive in construction of the hospitals or in the construction of the schools. But main purpose is not the profit earning. So non-profit organization, section 8 is there. And this case is totally related to the section 8. And citation civil appeal number 1430 of 2018. Amity Universities versus New Okhla Industrial Development Authority. Now, I am turning over towards case number 3, Satyam Computer Services Limited versus State of Andhra Pradesh, 2018. In this Satyam scandal, the situation involved allegation of fraud and misleading shareholders. And decision, the court underlines the responsibility of the board concerning corporate governance. These were the major effect of the decision. The court underlines the responsibility of the board concerning corporate governance. And ratio dissenting come out of this case was director must act in the best interest of the shareholders and the companies. And section 134 financial statements. Citation of this case, civil appeal number 1805 of 2018. Now, case number 4. Messrs. Kridan Infra Limited versus State of Maharashtra, 2020. Facts. The facts means short point raised in this case. A dispute arose regarding the registration of a company and its compliance with the state law. So when there is a company law also involved and local laws also of state involved. So local laws also will have to compliance. So this is the main case. The Supreme Court upheld the right of companies to register subject to state law compliance. So Supreme Court upheld the right of companies to register subject to state law compliance. Ratio dissenting. Registration of a company is preliminarily regulated by the Companies Act, although local laws must be followed. And this is related to section 7, incorporation of company, and citation 2020 SCC online SC 1307. Now, case number 5. This is related to insolvency. ArcelorMittal India Private Limited versus Satish Kumar Gupta, 2018. This case was concerned with the eligibility of a company to acquire another company under the Insolvency and Bankruptcy Code. And decision comes out of this case. Supreme Court decided on eligibility criteria regarding the past conduct of prospective acquirer. So what is the past conduct of the prospective acquirer? And according to that, eligibility to take over will be decided in the Insolvency and Bankruptcy Code. Fortunately, with the grace of God, I am a insolvency professional also with advocate in Supreme Court of India. And that examination was very hard. CA face it very easy because CA regularly involved in practical process also in Companies Act, CACS. But this examination was very hard for a lawyer. I failed 8 times in this examination, and 9th attempt I cleared this examination because negative marking system is there. So many problems and so many acts are there, and every time you appear, you will find your examination level tough and tough and tough and tough. And 60% you should have. And in my first attempt, I got marks 58. If I have not ticked wrong answer, definitely I will clear that examination in first attempt. But I click some wrong answers and my marks goes to 58. Only 2 marks are less. Second attempt 56. Third attempt 59.5. But in 9th attempt 60. I clear and I am now insolvency professional. What are the criteria to become insolvency professional examination? Just go to IBBI website. Insolvency Bankruptcy Board of India website. You will get that. Now, ratio descending comes from this case, this ArcelorMittal India Private Limited case was past conduct impact the eligibility of parties under corporate restructuring laws. When corporate restructuring laws is applicable, that time a company which is taking over the affairs of earlier company called corporate debtor, so past conduct will impact definitely. So past conduct is clear, there is no issue. But when past conduct is malicious, fraudulent, then a company which is taking over the affairs of corporate, they are not allowed to do that. So ratio descending of this past conduct impact the eligibility of parties under the corporate restructuring. I can elaborate, I can give you full decision, everything, but I cannot cover more cases. So I have decided to give 1, 2, 3 lines only so that I can cover maximum cases. And I will definitely assure you that through this Nani Palkiwala National Law Club series, twice in a week, I will take this session of 10 to 15 laws on different. So you will get the bunch of the laws, and whenever you are leisure, early in the morning, while you are exercising or while you are fresh, you can just play this on YouTube, because all these this webinar will be will post on YouTube channel. My YouTube channel is there, Jayprakash Somani. Just type Jayprakash Somani, you will get my YouTube channel, and you can subscribe there. Whenever you will get new video, you will get updated. More than 300 videos are there. Now, case number 6, Sunil D. Dolakia versus Security Exchange Board of India, SEBI, 2020. This case dealt with the violation of insider trading norms as prescribed under the Companies Act. So SEBI have a proper control on insider trading. SEBI's complete working pattern is different. SEBI is controlling the affairs of the company specifically related to the securities. Decision: penalties for insider trading were upheld. So SEBI owned this case. Penalties for insider trading were upheld. There is my book on insider trading, case laws on insider trading, and we will take some separate case laws on also insider trading. One Nani Palkiwala show will conduct for insider trading. So, what is insider trading? Insider trading means when company's employee or company management or any maybe SEBI officers, anybody knows the inside news about the dividend or other things, and before declaring that, before that decision comes on the public platform, and they are purchasing share from the market, and then they are taking the undue advantage of that to earn money. When in share market somebody is earning money, somebody is losing money. And this is because of only these people have the news inside. So this comes under insider trade. I am giving you example in very simple ways. And such type of cases happen. SEBI tribunal decided that. Then appeal goes to appellate tribunal of SEBI. And after appellate tribunal of SEBI, Supreme Court is there to decide that. So in this particular case, in Sunil Dolakia versus Security Exchange Board of India, decision: penalties for insider trading was upheld. Ratio decidendi: preventing insider trading is central to maintaining market integrity. And section 195 penalties for insider trading. Not a heavy penalty, insider trading. 1 crore, 2 crore, like that. Not a, जैसे हमारा सुप्रीम कोर्ट कॉस्ट करता है ना एडवोकेट को 10,000, 5,000, 25,000. No, these penalties are only on large scale because they are earning huge amount through this misappropriation of that information before public getting that information. So to control that, this particular case is very important. Now, section 195 and citation of this case is 2020 SCC online SC 860. Case number 7, Vijay Mallya versus State Bank of India, 2019. The proceedings against Mallya highlighted issues of corporate loans and fraud related to the Companies Act. Decision: enforcement of loan recovery was upheld, emphasizing accountability. Ratio decidendi: companies need to maintain transparency with respect to the financial dealings. Very great and good decision of the apex court in this case. Section 177, Audit Committee. So when such type of a case comes to you, that time you have to refer Companies Act and also with audit rules. So you can defend properly to your client. Many lawyers are using only Companies Act. They are not observing the rules. The rules are very important because rules shows the procedure, how that law will be implemented, and law shows only law, bare acting. Citation of this Vijay Mallya case, Civil Appeal number 213 of 2009. Case number 8, Chetak Logistics Limited versus State of Madhya Pradesh, 2014. This case revolved around a company's operational compliance with local taxation laws. So here issue was company's operational compliance with local taxation laws. Decision: the court emphasized the need for proper tax compliance by businesses. So ratio decidendi comes out of this case was all companies must adhere to local laws in conjunction with the Companies Act. And sections, various sections related to the compliance and tax. Section 142. And citation, Civil Appeal number 2727 of 2014. Friends, case number 9. K.R. Choksey Shares and Securities Limited versus Union of India, 2015. The case dealt with the interpretation of penalties under the Companies Act regarding the violation of regulatory requirements. Interpretation of penalties under the Companies Act regarding the violation of regulatory requirements. Decision: it reaffirms the strict enforcement of compliance regulations. So compliances as per Company Act should be strictly enforceable. Ratio decidendi: regularity compliance is crucial for operational legitimacy. Regularity compliance is crucial for operational legitimacy. And section 447, which is related to penalty for fraud. And citation 2015 SCC online SC 1037. Friends, now case number 10, Madhya Pradesh High Court versus Bank of India, 2018. Facts: The matter regarded lender's right in insolvency proceedings. Matter regarded lender's right in insolvency proceedings. This is related to insolvency. And decision confirmed that lenders retain rights under the Companies Act during insolvency issues. And ratio decidendi, the lender's rights are paramount in insolvency proceedings. Section 241 comply application for relief from operation. And citation 2018 SCC online SC 1730. Then case number 11. Ravi PV versus Indian Oil Corporation Limited 2020. The case focused on the wrongful termination of employment by a public sector undertaking. Public sector undertaking. Wrongful termination of employment by public sector undertaking. That means public company. Decision: the right of employees in public sector corporations were recognized. So this is in favor of employees. Ratio dissenting come out of this case was public sector companies must adhere to fair employment practices. So you can use this case laws in service matters other than companies. Section 134 financial disclosure here, and citation of this case was 2020 SCC online SC 890. Case number 12. Yan R. Dongre versus Whirlpool Corporation 1996. This older case laid foundational judgments on the application of the Companies Act concerning intercompany dealings. This older case laid foundational judgments on the application of the Companies Act concerning intercompany dealing. Decision confirmed that all transactions must align with corporate governance protocols. Ratio decidendi, corporate governance is essential for protecting stakeholders. And section here 372, intercorporate loans. And citation of this case AIR 1996 SC 1007. Friends, case number 13, Shubham Enterprises. Shubham Enterprises versus State of Haryana 2019. Fact, issues. Short issues, short. I'm not giving detailed fact because unnecessary discussion, because we are practicing Supreme Court and our Supreme Court practice is not related to the facts. This is related to the substantial question of laws. Facts are essential in the trial court. Trial court of company law is NCLT. Facts are essential there. But in appellate level, you have to argue on the substantial question of laws. So I'm covering that so that you will get the help of these judgments in practicing specifically in NCLAT and specifically in Supreme Court. And also in NCLT you can refer these cases. Dispute involving the registration of firm under the Companies Act framework. And decision, Supreme Court affirms the right of businesses to operate in compliance with the Act. And ratio decidendi, businesses must satisfy all regulatory requirements to operate legally. Section 149, company to have board of directors. And Citation Civil Appeal number 7780 of 2019. Case number 14. Public Interest Foundation versus Union of India, 2019. This case is regarding the conflict of interest in board decision. And Supreme Court decision, the significance of transparency in board actions was emphasized. So in all board members, significance of transparency, Supreme Court emphasized. So there should be a transparency in board of directors. Ratio dissenting comes out of this case was directors have fiduciary duties. Fiduciary means very trusted duties. Fiduciary, this is Contract Act word. Directors have fiduciary duties that must be honored to prevent conflicts. Section involved in this case, main section 184, disclosure of interest by directors. Citation 2019 SCC online SC 1241. And last case of today's discussion is case number 15, State of Maharashtra versus R.R. Chaudhary, 2018. Matter concerning the closure of company and its compliance with the Companies Act. Decision: company closure procedure must follow statutory guidelines closely. So, company's closure procedure must follow statutory guidelines closely. Properly, statutory guidelines should be there. That should not be ambiguity. There should not be ambiguity between the guidelines. There should be clear cut, understandable guidelines should be there. Ratio descending, adhering to formal procedure is necessary for statutory compliance. Section involved in this case was Section 248, power of registrar to remove names of companies from the register. And citation is 2018 SCC online SC 1530. So this is the main glimpse of today's 15 cases. Next, I will take the 15 cases on criminal law. Next, I will cases on service matters, because I don't want any stamp on me. I am corporate lawyer, I am a service matter lawyer, I am a criminal lawyer. I don't want any stamp. Since last my 35 years practice, I have maintained that. I don't have any stamp. I am ready to practice in any stream, because we are handling with the gross Lord Krishna's grace. We are handling our Supreme Court firm, law firm in here in Delhi with 12 my associate advocates. Out of that, 5 are AWAR, and we are handling all matters, criminal. So we don't want any stamping. So we will cover different acts, and you will be witness there. And all our programs will manifest properly. So Manoj, you can unmute yourself now and conclude this session.
Thank you very much, sir. I thank you all the participants who has gone through the different 15 cases which are related to the IBC and which are related towards the compliances and fraud related. Thank you once again, everybody, for joining us. Thank you, sir.
Thank you. Thank you.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं, जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं जो Amazon और फ्लिपकार्ट पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में ज़रूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।